have spoken at a number of events about the amendment, and certainly, far and away, this has been the most uplifting, the most joyful. Full of fellowship, and I hate to destroy this mood by talking about the amendment. But I believe I have been asked to be the wet blanket here, the storm cloud that rains on your parade, and I'm going to go ahead and do that. Marriage between one man and one woman is the only domestic legal union that shall be valid or recognized in this state. 22 short words. They would take away rights and protections for hundreds of thousands of North Carolina families. When Amendment 1 was being considered in the General Assembly, its proponents said that all this amendment did was take our current ban in North Carolina law against same-sex marriage and put it into the state's constitution. If the proponents of the amendment had wanted to do that, they certainly could have done that. They could have said that marriage between one man and one woman is the only marriage that will be recognized in the state of North Carolina. In fact, they had the North Carolina House version of the bill that said exactly that. Instead, they chose to use the broader language from the Senate bill, and in doing that, vastly expanded the range of prohibitions that this amendment would put into the North Carolina Constitution. One thing we teach our students at law school, that law is all about interpreting language. Students come to law school and what they expect to do is learn the law. And what we teach them is they need to learn about interpreting language. And by saying that heterosexual marriage is the only domestic legal union rather than marriage that should be valid or recognized in the state, the General Assembly broadened the scope of the law far beyond same-sex marriage to strip rights and protections from all unmarried couples, whether they are opposite sex or same-sex. So what does the amendment's language in its current form now do? What does it mean? Before we change our Constitution, our state's bedrock legal document, it seems like we should have a very good answer to that question. But we don't and we can't. I have spent, I think, more time than anybody else in the state parsing the language of this amendment, and I can't tell you what it means. That's because the term domestic legal union has never been used in North Carolina law before. It's never been interpreted by courts in this state, and indeed, it's never been interpreted by courts in any other state. What that means is that courts ultimately are going to be the arbiter of what this language means and recognize that is a very peculiar result for an amendment that supporters say is designed to take important family issues out of the courts. Nationwide, there are 29 states at this point that have passed these kind of amendments. Our amendment is broader than almost every single one of those other amendments. A number of those amendments simply prohibit same-sex marriage. They take basically what is in our state law and they have put it in their state's constitution. Most of the other amendments that have been passed in states prohibit both same-sex marriage and the state's creation of some kind of equivalent legal status. Our proposed amendment, though, goes far beyond either of these. It says that the state can't recognize any domestic legal unions, both for same-sex couples and opposite-sex couples. And if courts read this language broadly, it would prohibit giving unmarried couples, same-sex or opposite sex, any relationship protections at all, not just protections that rise to the level of marriage. It's because of the potentially broad reach of this vague and untested language that family law professors in every law school in this state have spoken out in opposition to the amendment. And I mean every law school in this state, at Campbell, at Charlotte, at Elon, at Duke, at UNC, and at Wake Forest. There are family law professors across the state that have been speaking out against this amendment. So how broad a range of protections would this amendment take away? In the immortal words of Donald Rumsfeld.
Oh, yes.
George W. Bush's Secretary of Defense, there are known knowns, there are known unknowns, and there are unknown unknowns. I can't even begin to tell you what the unknown unknowns will be of this vague and untested language, but let me talk for a minute about the known knowns and the known unknowns. So in terms of the known knowns, we know that whatever the ban on domestic legal unions means, it is certainly broader than the state's existing ban on same-sex marriage. There is no doubt about it. Although proponents in the General Assembly said all this did was prohibit same-sex marriage, a number of them, including one of the chief proponents, Representative Skip Stam, now admits that that the language of the amendment goes far beyond prohibiting just same-sex marriage. Representative Stam admits that it would ban civil unions. Representative Stam and other proponents now admit that it would ban domestic partnerships at the state level. And Representative Stam and other key proponents also admit that it would take away the domestic partner insurance benefits that 9 municipalities and counties now give to their public employees to protect the domestic partners of their public employees and the children of those domestic partners. Let me be clear, if the amendment were passed, there is no dispute that these benefits that families are currently receiving would be stripped by the amendment. And if the amendment passes, North Carolina could never allow second parent adoption, as many states do, which give both committed partners a parental tie to their child and are uniformly agreed to be in the best interest of children. So these are the effects that are relatively certain, the known knowns. Let me talk about the known unknowns here. And there are many of them. We don't know how courts will interpret the language. Anybody that tells you definitively that they know is telling tales. But if courts interpret this language broadly, it could eviscerate a number of the rights and protections we give to unmarried couples. Probably the biggest concern here is with domestic violence protections. In North Carolina, we years ago decided that people who are victims of domestic violence deserve protections regardless of their marital status. When Ohio passed a narrower marriage amendment in 2006, courts went through 3 years of havoc and more than 30 cases in which domestic violence charges had been leveled against unmarried persons were either dismissed or overturned on appeal. In one of these cases where a victim sought a protective order against her boyfriend on the ground that he bruised her ribs, punched her in the eye, tried to drown her, slammed her face into a steering wheel, and tried to choke her, the court dismissed her motion for a protective order. Not because it found that her boyfriend didn't do those things, but because she wasn't married to her abuser. Eventually, after almost 3 years of confusion in the Ohio courts, The Ohio Supreme Court reinstated those domestic violence protections for unmarried couples. It did so, though, based on the fact that what Ohio's amendment prohibited was legal recognition for same-sex couples that rose to the level of giving the protections of marriage. Now recognize that that's exactly the kind of limiting language we don't have in the North Carolina amendment. And if courts in our state were to adopt the language that the rationale that Ohio courts use, our domestic violence protections would fall. In addition to that, courts, if the amendment were passed, could roll back child custody and visitation rights for unmarried partners that have been established by courts to further the best interest of children. On top of that, the amendment would prohibit the state from giving further limited rights to committed unmarried couples that other states now provide. There are a number of states out there that have decided that they want to reserve marriage for heterosexual couples, and even reserve all the benefits of marriage for heterosexual couples. But even these states have decided that for reason of fairness, basic humaneness, and for the welfare of these couples and their children, it makes sense to give some individual rights to support these families. So Maine, for example, allows committed domestic partners to make funeral and burial arrangements for if one dies before the other. Maine also would put committed domestic partners on the list of people who have priority to be named guardian or conservator if their partner becomes incapacitated, and also to inherit from one another if their partner dies without a will. These protections, protections that some states have adopted that would put committed domestic partners on the list of people who get automatic family hospital visitation privileges, all those things could be prohibited if the amendment were passed. Amendment 1 is so broad that even leading national policy advocates in favor of traditional marriage are standing up to oppose it. Last week, David Blankenhorn, the founder and president of the Institute for American Values, published an op-ed piece in the News and Observer saying that he opposed North Carolina's amendment and urging voters to vote against it. Now, the significance of Mr. Blankenhorn's editorial might not be clear to those of you who don't follow family law and family policy, but for those of us who do, it was earth-shaking. Mr. Blankenhorn is one of the most well-known advocates in the country in favor of traditional marriage. He was the key expert witness in favor of California's amendment when it was put on trial in federal court. And even he rejects the North Carolina amendment as going much too far because it would ban the state from extending legal recognition and protection beyond marriage to same-sex couples. In Mr. Blankenhorn's and his co-author's words, that's mighty cold. I'm continuing and give you a few sentences of what he says. If you disdain gay and lesbian persons and don't care whether they and their families remain permanently outside the protection of our laws, such a policy might be your cup of tea. But it's not our view, and we doubt that it's the view of most North Carolinians. Because of the overreach of this amendment, politicians of all stripes and from all parties have come out against the amendment. Harvey Gantt and Richard Vinroot, both former mayors of Charlotte, one a Democrat, one a Republican, both have publicly opposed this amendment because of the serious harms it could cause to North Carolina families. There are times when, as citizens in a democracy, we have to make hard choices between competing goals that we care a good deal about. This is not that vote. This vote is not a hard choice, and it is not a hard choice if, as I'm sure is true of many of us, you steadfastly support heterosexual marriage and you think that heterosexual marriage is a fundamental building block of our community. When I talk about this point, I often talk about one of my favorite New Yorker cartoons, and in it there is a kind of dumpy, middle-aged man with his middle-aged wife, and they are standing next to the door of their house, and the wife has a suitcase in her hand. And she looks at her husband and she says, "It's not you, honey, it's same-sex marriage." The reason that the cartoon is funny, because we intuitively know that relationships are not a zero-sum game where taking points away from one sort of family and giving them to the other helps that other family. It doesn't work that way. In clear empirical evidence bears this point out on a statistical level. There is not a shred of evidence, and I mean a shred of evidence, that marriage amendments like this one do a single thing to protect heterosexual marriages. Evidence from other states clearly demonstrates that states who pass this amendment don't have their divorce rates fall. They don't have their marriage rates rise. I mean, this is laughable, and here I am, because this is perhaps the fundamental argument behind the pro-amendment campaign. I've been married for going on 21 years to my husband. We have 3 children at home, and we, because of that, are protected by the full range of rights and protections that both North Carolina law and federal law provide us. And the fact of the matter is we have needed every one of those protections. Some of you know that one of my kids has medical issues, and those insurance protections and those caretaking protections, have been crucial in our family. Passing Amendment 1 will do not a single thing to help my kids or my family. Not a single thing. The only thing that it will do is strip rights from unmarried couples, both same-sex and opposite sex, and hurt them and their kids. Yeah. In closing, I want to talk about what we're seeing in recent polls. If the vote were held today, according to a recent poll by Public Policy Polling, there is no question that this amendment would pass by a considerable margin. 58% of North Carolinians deemed likely voters say they would vote for the amendment. Only 38% said that they would oppose it. Yet, the same poll showed that 51% of voters supported some form of legal recognition for same-sex couples. 26% of them said they supported marriage, 25% said that they supported civil unions, only 45% completely opposed any recognition for same-sex couples. So the question you are asking now is, how can it be that a majority of voters say they would vote for this amendment when a majority of voters are opposed to what this amendment actually stands for? The answer is that only 31% of the voters being polled understood that Amendment 1 did more than ban same-sex marriage. 7% actually thought that it would legalize same-sex marriage. Yeah. So that's an issue for another day. When voters were informed that this amendment banned both same-sex marriage and civil unions, support dropped off rapidly. Only 41% of voters said they'd support the amendment knowing that, while 42% were opposed. So what does this tell us? It tells us that the only way to turn this situation around is to have a massive campaign of education. And what that means is that everyone in this room needs to get the word out. We have 22 days left until the election. That means you need to talk to everybody you know. You need to use Facebook. You need to email everybody in your address book. You need to help the coalition phone bank, canvass, and if you can, give them money to get the word out on the air. Unless we all make this effort, North Carolina is going to pass an amendment that will strip critical rights from North Carolina families, even though voters don't understand its scope, wouldn't agree with it if they did, and we are going to live with the harmful effects of this amendment for a very long time. Thank you.